everybody. I'm Eric Scranlin, and this is the Tactical In-Service Podcast, a podcast for law enforcement. In this podcast, I discuss legal strategies and topics to help you stay up on the law. In this very first episode 1, I'm going to get back to the basics. I'm going to talk a little bit about reasonable suspicion today. Why reasonable suspicion? Well, as a prosecutor, one of the most common issues that I dealt with was suppression motions where the issue was, did reasonable suspicion exist to support the traffic stop or the detention? In the civil field, it's a very common attack from plaintiff's counsel, and it's a very common issue in Section 1983 liability cases. So very important stuff to know. Even though it seems pretty straightforward with reasonable suspicion, this is something that you use as an officer in your daily job all the time. It's actually very complex. And what I'm going to talk about a little bit here today, I'm going to talk about some United States Supreme Court cases. The courts have not even really truly been able to define it. In fact, they refuse to, as they say, put it into a neat set of rules and guidelines because of the vagueness of reasonable suspicion and the way that our courts define it. It can create some confusion. So what I'm going to talk about today is something that I've put together as a prosecutor over years and years of doing suppression motions, researching the case law. It's kind of a 3-step guide, a methodology. Now, I don't expect you as an officer to be out on patrol and kind of like, oh, check 1, check 2. This is more of what I preach about. Every battle is won before it's fought, meaning that you have to be prepared for these situations mentally. And this is a methodology that you can use as you approach any situation that you get into. So I'm going to give you that today in this episode. But before I get started, make sure you subscribe to the podcast. This is a brand new podcast. This is episode 1. And one of the things that I really want to do with this podcast is whenever a new case comes out, a United States Supreme Court case, a big federal court of appeals case for my New Mexico officers, New Mexico Supreme Court or Court of Appeals decisions, I'm going to break it down and I'm going to get on here and I'm going to do an episode on it so I can give you everything you need to know about that case. So make sure you subscribe to the podcast on whatever app you use to listen to podcasts, and also subscribe if you're watching this on YouTube to the YouTube channel so you get the notifications when a new episode comes out. Let's dive right into this reasonable suspicion stuff. Okay, so if you're watching this on YouTube, you can see I got a PowerPoint up on the screen here. I'm just going to walk through my 3-step approach and a little bit of background. If you're listening on the podcast and you want to see the PowerPoint, just jump over to the YouTube channel, Tactical Attorney. It'll be there. You can also go to my website, tacticalattorney.com, to get all these resources for free. So, okay, let's talk about reasonable suspicion. Essentially, we're going to jump right into where it all kind of started, which is Terry v. Ohio. So let's kind of get into the basics of what we're talking about here. What I'm talking about here is the investigatory stop. Okay, so this is your typical patrol officer turning the lights on and making a traffic stop. Or if you see, someone walking down the road that's potentially engaged in activity, turning on the lights, stopping them. It's a detention. Under a detention, the Fourth Amendment applies, and you know that you need to have a warrant or an exception to the warrant requirement. Okay, so today we're going to be talking about reasonable suspicion, an exception to the warrant requirement. What Terry versus Ohio tells us is that these investigatory stops occur when an officer briefly detains and investigates a person based on reasonable suspicion of criminal activity. Okay, so, what are the courts talking about here? How do you define reasonable suspicion? And what we find from the courts is we get tests and we get factors to look at, but the courts have admitted that it's difficult to define. In fact, in a famous United States Supreme Court case, Ornelas versus United States, the site's 517 U.S. 690 from 1996, the courts come out and say it. They say articulating precisely what reasonable suspicion and probable cause mean is not possible. What? Really? Yeah. So instead, what the case law tells us, and this is important for you to understand, is that you have to focus on the big picture. Okay, what do I mean by the big picture? I'm talking about what the courts tell us is that totality of circumstances thing that they're always mentioning in cases. So when you hear the courts say you need to focus on the totality of circumstances, What they're talking about is they want you to put everything together and create a big picture analysis. That's why they say it's difficult to frame this in terms of some neat set of rules, because they want to look at the big picture. You know, the courts that told us, going back to United States versus Cortez, I'm not going back to it, but this is a case you're going to want to be familiar with, a Supreme Court case, United States versus Cortez, 449 U.S. 411. The courts say, look, we've used a lot of different terms to try to capture this elusive concept of what cause is sufficient to authorize police to stop somebody. They use terms like, and you've heard this before, articulable reasons, founded suspicion. And they say these are not self-defining, and they're not going to provide clear guidance on what this means. It just depends on the situation. Instead, the courts tell us, and this is big, that the essence of all that's been written in all the case law is this: totality of the circumstances. What is the big picture? And that's what you must take into account. So you don't need to get necessarily tied up with these fancy legal terms. What you need to take from all the case law combined is that there really is no neat definition. It's what's the big picture tell you. Okay, so what do the courts focus on when they're looking to create that big picture? Well, there's three specific things that they're looking for. First of all, they're looking for specific facts, not vague things. I'm going to talk about this in a minute. Not the defendant was behaving in a suspicious manner. That's a conclusion. You need to be specific on the facts, okay? And when then they bring up this articulable facts, you hear that a lot when you hear a discussion on Terry versus Ohio. What do they mean by that? Well, they just mean facts that you can articulate. They don't want to hear conclusions like, again, suspicious activity. They want you to articulate what facts tell you that this is suspicious activity. And they also mention, and this is a big one, and this is where we kind of get into the transitioning into making the final decision here, is rational inferences. Okay, what am I talking about with rational inferences? Once you see the facts and you articulate the specific facts, what can you as an officer infer from those facts? Can you infer reasonably that this is criminal activity? And there's a little bit more that goes into that, but we'll talk about that in just a second. Eric's Guide to Reasonable Suspicion, as I've called this, it's not an official guide. It's not used by the Supreme Court. This is something that I came up with throughout my years of being a prosecutor, in looking at all the case law and saying what common things are there. And I found that this is a methodology that you can use as an officer to determine whether or not you have reasonable suspicion. So it's one of those things that it's a mental checklist that helps prepare you for any situation you get into. So, all right, step one, you need to ask yourself, what crime do I see? And when you ask that question, what crime do you see happening right now? What crime is about to happen? What crime has been committed? So specific. Okay, what crime do I see? And you need to be specific. If it's a burglary, you say burglary. If it's a drug deal, you talk about a drug transaction. You have to be very specific here. Remember, when we're creating this big picture analysis, the court wants to see specific, articulable facts. So you need to identify specifically the crime you see. Then you move to step two, where you ask yourself, what facts do I see to support step one? So what we're talking about here, like I've been saying, is you got to be specific. Okay, the court does not want to see, I saw a defendant behaving in a suspicious manner. They want to hear the facts that tell you as an officer that this behavior is suspicious. Okay, so you be specific on the facts to support the crime that you've named in step one. Finally, step three, once you've identified the crime and you've identified the facts, you need to take a step back and say, is this more than a hunch? Now that sounds kind of vague, and it is. And it's one of those things where if you do a detailed analysis of step 1 and 2, it makes 3 a lot easier. And the courts, again, kind of give us a little guidance on what's a hunch and what's not. And there's a couple things I'm going to talk about here in a minute that may help with that. But these are the 3 steps that you need to have down. Identify the crime, be specific with the crime, be specific with the facts that support it, then take a step back and say, is this more than a gut feeling, or can I make rational inferences that lead to the conclusion that there may be criminal activity afoot? I also think it's important to remember that the ends don't justify the means. You know, you can't make observations after you turn the lights on, after you make the detention. You can't say, oh, well, I found drugs, so therefore there was reasonable suspicion. No, it doesn't work that way. You need to have the crime identified, the facts, and the inferences before the lights go on. You don't get to use what you found to buff up the reasonable suspicion. It's got to exist before the lights turn on. And again, I can't mention this enough because as a prosecutor, one of the red flags that I saw that would always trigger emotion and would always come back to haunt the officer during the hearing, because he would get crossed on this, he or she would get crossed on this by the defense attorney, is things like, I responded in reference to a suspicious person call. I noticed the suspect was acting suspicious, or the suspect was crouched in a suspicious manner. Okay, what's wrong with these statements? Yeah, they're conclusions. Again, the court wants specific facts. So you need to list in your complaint, in your report, what the specific facts are that you saw that led you to believe the suspect was acting suspicious or crouched in a suspicious manner. You need to be detailed in those facts. It's very important. Okay, let's walk through a little example here of how this stuff kind of works in practice. So this is a case from New Mexico. Essentially, we have a concerned citizen who calls in the police department. It's actually like a neighborhood watch person that's always watching, looking out, and actually has like the patrol sergeant's cell phone. So it sends a text, says, hey, there's a car. It's in our neighborhood. It's around 11:30 at night. I don't recognize it. It doesn't look like it belongs here. It's been sitting out there for like 30 minutes, and it looks suspicious. And the officers know that there had been burglaries recently in the area. None at that house. None maybe in the houses that are close. Just recently in that area, generally speaking, there had been some burglaries. None that night, maybe not even none the night before, but recently in the area. So patrol officer sends a vehicle out and a unit out. The unit sees the vehicle. There it is. Matches the description. It's parked on the side of the road, right where the caller said it was. I should mention, no violation. It's not a parking violation. And other than what the caller had said, there's nothing illegal about how the car's parked there. So there's a driver and there's a passenger. Do you have reasonable suspicion to turn the lights on and conduct a traffic stop? Walk through the steps. I'm going to take it a step further too, because it was actually the passenger that was the defendant in this case. So do you have reasonable suspicion to support detention of the passenger? So let's walk through it. Step one, what crime do you see? Okay, you can see now why I'm specific with these steps, because you get a call for suspicious activity, burglaries in the area. You just kind of come out there, oh, well, there's the vehicle, I'm going to turn my lights on. But when you get in court, you need to be able to explain this stuff. So what crime do you see? Well, the car's parked there legally. There's nothing illegal about that. If you had to think about it and you got to pick something, what are you going to pick? You're going to say, well, maybe they're casing a house for a burglary, like the Terry v. Ohio case. That's probably the best you can go with at that point, right? Okay, what facts do you have to support it? Well, okay, it's 11:30 at night. They've been parked on the side of the road for 30 minutes, and there have been burglaries in that area. Okay, so you've identified a crime. You have identified some facts, but let's go to step 3. Is this more than a hunch? Okay, this is where it becomes a little tricky. You need to go back and you need to look at your facts, and you need to look at some rational inferences. Can you really infer from the fact that a vehicle's parked on the side of the road, well, there's nothing illegal about doing that, that they're engaged in possibly about to commit a burglary on those facts alone? Probably not. You're right to be thinking that probably not. And of course, our courts in New Mexico told us in City of Roswell versus Hudson, 141 New Mexico 261, if you want to look the case up, that there was no reasonable suspicion to detain the passenger. They didn't address the driver because the driver wasn't arrested and charged with anything, so he didn't have a case. But probably the same would have applied here. Because what happens is the officer goes to the vehicle, talks to the driver. The driver says, I live here. Looks at the driver's license. It's not the address. So the officer says, well, what the heck? Why are you lying? And then he says, well, actually, the passenger lives here. So the officer goes to the passenger, demands that the passenger hand over his ID. Side note, what do you have to demand someone turn over their ID? Yeah, you need to have reasonable suspicion. The officer didn't. And the passenger refuses to turn over the ID, gets arrested under City of Roswell's municipal ordinance of concealing ID, and the case goes up to our state Supreme Court. And our court says that the officer had no reasonable suspicion to detain the passenger based on these facts. They said the totality of circumstances, remember the big picture, failed to establish any reasonable, individualized suspicion that the defendant passenger was breaking or had broken any law when the officer demanded that the identification be turned over. So City of Roswell versus Hudson, this is an example where we go through step 1, step 2, step 3. You identify a crime. It's kind of vague, but you can identify it. You can identify some facts, but you get to step 3, and this is a generalized suspicion or a hunch. Those rational inferences just can't get you there. Okay, so again, one thing that I want to, one thing that I want to talk about that kind of ties into this with step 3 is that when you're making reasonable inferences, it's important to know that you can make reasonable inferences and deductions to support reasonable suspicion based on your specific training and experience. Okay, take a look at United States versus our VZU, I think is how you say it. It's 534 U.S. 266, 2002 case. Okay, this is a case that involved Border Patrol making a traffic stop on someone where the Border Patrol officer had specific knowledge of the area, the geography, and even though he didn't witness any traffic violations based on the area, the geography, and his training experience as a Border Patrol agent, the United States Supreme Court said that he could draw on that specific training experience to make rational inferences that would support the fact that this was smuggling, either human trafficking or drugs. Okay, but again, it cannot be based on hunches. So I'm going to talk a little bit more about that Arvizu case in a later episode and how to draw on your training and experience. But for today, I just want you to realize that case is out there. And for my New Mexico officers, there's a case that just came out called State versus Martinez. I'll give you the site for that. Martinez is 2020 New Mexico Supreme Court 005, where they have something analogous where an officer that had specialized training in narcotics could rely on that training in order to make inferences about something that he saw to make a stop. But I'm going to do an episode on that later, so look for that episode, probably episode 4 or 5. Okay, so I know that's a lot kind of to take in, so let's do a quick recap here. All right, step 1 on the Eric's Guide to Reasonable Suspicion is to identify the crime. What crime do I see? And again, remember, you're creating a big picture analysis here. Once you've identified the crime and you're specific about it, go back and say, what facts do I see to support step 1? So what specific facts do you have to support the crime? Again, be specific, no conclusions. And then finally, take a step back. Is this more than a hunch? So what you're doing in this step is you're taking your facts and your crime and you're making rational inferences from those facts to tell you whether or not this is a hunch or if it actually is reasonable suspicion to make the stop. So I'm born and raised in Michigan. Think of inferences this way. I go to bed at night. It's January. It's freezing cold outside. Nasty night. There's clouds in the sky. And the ground's frozen, but there's no snow on the ground. I wake up in the morning, and there's a foot of snow on the ground. I open my door, got to go and clear the car off and all that stuff, warm it up. Based on my experience of living in Michigan in the wintertime, I can infer from the snow that's on the ground and on my car, the fact that it was 20 degrees last night, that it's January, I can infer that we had a snowstorm last night and snow fell from the sky. Those are very rational inferences to make. The same applies here. When you identify a specific crime and specific facts that are consistent with that crime, you can make rational inferences about those facts that lead you to believe that criminal activity is afoot. Okay? Is it more than a hunch is when you can't make those rational inferences or you got to stretch it too much. For example, the classic, you see a person leave a known drug house, just walk out the door and walk down the sidewalk. Okay? Yeah, they left a known drug house, but they haven't done anything to give you a rational inference that they actually have drugs on them, other than the fact they left the drug house. That's a hunch. You need specific facts. Like maybe you saw them in the driveway of a known drug house and do a closed fist hand-to-hand deal. We have we have federal case law to support that at the appellate level. But that's kind of what I'm talking about. You need to be able to differentiate between the two. I hope this gives you a better understanding of reasonable suspicion. This is just a little tool that you can use, a methodology to help walk you through the situation. Whatever situation you may be in, if you apply this methodology to that approach, I think you'll be generally good. Of course, you need to go out and read the case law and be familiar with all the nuances, and make sure you subscribe to this podcast, because as new case law comes out in this ever evolving field, I'll give you updates on it. I'll talk about it. And in future episodes, I'm going to dive in more specifically to some other issues like drawing on your training experience. I have a couple of cases. I'll dive into that Arvizu case a little bit more. And for my New Mexico officers, I'll dive into some of our case law and how our interstitial approach analysis may be a little bit different. So make sure you subscribe to the podcast. This is my first episode. I hope I did all right. I'm looking forward to doing a whole bunch more of these with you guys. Subscribe to the YouTube channel. If you find any value in this and you want to contact me, you can go to my website at tacticalattorney.com. All my contact info is there, my email address. You can call me, you can text me, and I'd be happy to discuss any of these topics with you. And I would really love the opportunity to invite you to one of my courses or come to your department and do a course. So give me a call and we'll discuss that. Until next time, remember, every battle is won before it's fought. Stay safe. We'll see you next time.
is a rule that if evidence is unconstitutionally obtained, that is, the government got the evidence as a result of Fourth Amendment violations, they can't use that evidence in court. And what happens is the defendant, that is the person charged, will file a motion to suppress. That is a motion before the court saying you can't use this evidence, government. You're not allowed to show the jury the evidence of my guilt, as a way of deterring the government from violating the law in the first place. And this goes back to a 1914 decision called Weeks versus United States, in which the Supreme Court said that that is, in fact, a remedy for Fourth Amendment violations, that the evidence can't be used. Now, it sounds very broad when you sort of hear about the history of it. Turns out that the exclusionary rule is available as a possibility in some cases, but there are a lot of exceptions to the exclusionary rule. It actually is not applied that often because of all these exceptions, but it's always sort of in the background as a possible remedy for violations of the Fourth Amendment. Here's the basic idea. If the government's unlawful search or seizure led directly to the discovery of evidence, that evidence will probably be suppressed as a violation of the defendant's constitutional rights. It has to be the defendant's own constitutional rights, but if there's a really direct connection, the officer breaks into someone's house without any cause, finds drugs in their kitchen, that's likely to lead to suppression. The tricky part is that sometimes that causal relationship is not so direct. Sometimes, for example, the government would have found that unconstitutional evidence some other way, or even there's someone else in the government who did find that evidence some other way. In that situation, there isn't a direct causal connection between the constitutional violation and the discovery of the evidence. In those situations, usually the courts say that evidence can be used against a person because it wasn't really directly discovered as a result of the constitutional wrong. So there's sort of a category that's like the core sort of direct connections, those lead to suppression, and then that's it. If it's a less direct connection, those exceptions to the exclusionary rule usually end up applying and saying the evidence can nonetheless come in. Mapp versus Ohio involves a search of a house that was owned by a woman named Doreen Mapp. They appeared at her home and they claimed to have a search warrant, and she asked them for the search warrant, and they realized, well, we actually don't have a search warrant. They pretended to have a search warrant. She grabbed it from them and she ran into the house. They chased in after her. They ended up searching the house and finding evidence not directly implicating her, but nonetheless that led to charges against her. And the question in that case was whether the exclusionary rule applies to the states. So the Fourth Amendment directly only applies to the federal government, but the 14th Amendment to the Constitution, and in particular, the Due Process Clause of the 14th Amendment, does apply to the states. And so a big issue, especially in the 1940s, 1950s, and 1960s, was whether the Bill of Rights, and in particular the Fourth Amendment, applies to state violations. The Supreme Court had held in a 1949 case, Wolf versus Colorado, that the exclusionary rule doesn't apply to the states, but that the right, the Fourth Amendment, does. That meant that the police were supposed to follow the Fourth Amendment, but if they didn't, well, no suppression remedy. In Mapp versus Ohio in 1961, the Supreme Court says, we're overturning that part of Wolf versus Colorado. We think the exclusionary rule needs to apply to the states. And the reason was the states really were not following Fourth Amendment rules without the exclusionary rule. The thought was you need to have that threat of suppression, that threat of losing your case, in order to ensure that the states had a strong incentive to follow the Fourth Amendment. Basically, if you're a police officer and you want to make sure the people that are searched, the evidence that's ultimately uncovered, actually can lead to criminal prosecutions. And the exclusionary rule aligns your incentives with following the law. If you break the law, that evidence won't be admitted, and the people who've committed the crimes can't be convicted. So what's your incentive if you want to make sure people can be convicted? You want to follow the law. So there aren't Fourth Amendment violations. And that was the basic idea underlying Mapp versus Ohio. It applies the exclusionary rule to the states. And since most policing is at the state level, not the federal level, that's a hugely important decision, maybe the most important Fourth Amendment decision ever decided.